Do want to take you out to some breaking news right now involving former President Trump, as the judge has fined the former president $9,000 for violating a gag order a total of 9 times amid his, quote, hush money case and trial. Prosecutors did allege the former president violated the order, which bars him from making public statements about witnesses and jurors a total of 10 times, and the judge concurred in all but one of those cases. The judge will hold a hearing Thursday on 4 more alleged violations of the order. The ruling is a rebuke for the former president, who had insisted that he was exercising his free speech rights. The ruling came at the start of the second week of testimony in that historic trial, which did get underway moments ago here. Trump is back in that Manhattan criminal courthouse in New York City because the judge has ordered him to be there every day of the trial that could last for another 3 to 5 weeks. Trump faces 34 felony counts of falsifying business records.
All right, friends, welcome back to Dr. John Podcast Family. When a sitting president treats subpoenas, gag orders, and testimony demands as optional, judges must escalate beyond standard tools, warnings, deadlines, and fines that have failed to compel compliance. The legal system is being pushed to confront a fundamental question. Can the rule of law hold a president accountable when he simply refuses to recognize its authority? The warnings get sharper, the fines get bigger, and eventually the judges start using a word that makes everything feel very different and very real in a very hurry. That word is jail. Not as a hypothetical concept buried in legal textbooks, not as a distant possibility hiding in legal footnotes, as a specific, documented, on-the-record judicial warning that if the defiance continues, the next step is incarceration. And that is exactly what has happened across multiple Trump legal proceedings.
And the charges stem from alleged hush money payments made to prevent stories from surfacing in the final days of his 2016 presidential campaign. That does include payments to adult film star Stormy Daniels. This is the first criminal trial of any former U.S. president and is also the first of 4 indictments against Trump expected to go to trial. Last week, David Pecker, the former publisher of the National Enquirer, testified that he pledged to be Trump's eyes and ears during the presidential campaign. Pecker did recount how he promised Trump that he would help suppress harmful stories and even arranged to purchase the silence of a doorman. Now, again, that ruling coming down moments ago as the judge has now fined former President Trump $9,000 for violating that gag order a total of 9 times amid his hush money case and trial that is now officially back underway for the day. We did hear from the former president as he was entering into the courtroom moments ago. Very short comments in nature, but I do want to pop up the audio here and listen in.
Judges have reached the point where they looked at the pattern of non-compliance and said clearly and publicly, this stops now or the consequences are going to be different from a fine. And the fact that we are talking about these warnings being directed at the President of the United States makes this one of the most extraordinary legal situations in modern American history. So stay with me, because today we are going to walk through every single moment of this story. The subpoenas, the contempt orders, the gag order violations, the jail warnings, and by the end, you are going to have the clearest picture you have ever had of exactly how serious the situation has become and exactly what it means for the rule of law in America right now. Before we get into the specific moments and the specific warnings and the specific legal proceedings, let's make sure everybody watching this understands something important about how the legal process actually works when someone defies a court order. There is a version of this story that sounds like a judge snaps their fingers and someone gets dragged off to jail instantly. That is not exactly how it works in practice, even when the situation is genuinely serious. The legal system works in stages when it comes to enforcing compliance.
Icebox for 8 hours, 9 hours or so. They took me off the campaign trail, but the good news is my poll numbers are the highest they've ever been, so at least we're getting the word out. And everybody knows this trial is a scam. It's a scam. The judge should be recused, and he should recuse himself today. It's the most recusable judge I've been. It's called recusal abuse, and he should recuse himself today. And maybe he will. Maybe he will. Maybe he'll do the right thing. But really, more importantly than the recusal, he should terminate the case today. The judge should terminate the case because they have no case. As Jonathan Turley said, as all of them said, every single one of them, Dershowitz, McCarthy, everyone, Greg Jarrett, Mark Levin, they all said, this case should be ended immediately. This case is over. It should be ended immediately. And many of them are not fans of mine, but they want to do the right thing for the country. So I appreciate you being here. Thank you very much. And I'm going to go into the icebox now.
First comes the order itself, the subpoena, the gag order, the testimony demand, whatever the specific requirement happens to be. Then comes a deadline for compliance. Then if compliance does not happen, comes a finding of contempt. Then come fines and sanctions designed to create financial pressure to comply. And then in cases where all of those tools have failed to produce compliance and the court is dealing with someone who is willfully and persistently refusing to follow the law, comes the possibility of incarceration. Jail, not as the first response, not as an instant consequence, but as the ultimate enforcement tool that courts have available when everything else has stopped working. Come on. And what makes the Trump cases so extraordinary and so historically significant is that judges in multiple independent proceedings have worked through enough of those stages that they reach the point where the word jail
And sit for about 8 hours or 9 hours. I'd much rather be in Georgia. I'd much rather be in Florida. I'd much rather be in states that are in play, states that, I'd like to be able to campaign. Biden's out campaigning, if you call it campaigning. He can't campaign because every time he opens his mouth, he gets in trouble. But Biden is out campaigning very nicely. I think when I start campaigning, he'll stop. He'll go back into his basement. But I want to thank everybody. You've really been treating me very fair. I want to thank Time Magazine. They did a cover story, which is very nice. And it's actually, there's at least 60%, it's at least 60% correct, which is about all I can ask for. So I want to thank you, everybody. Thank you.
Are you going to part of the crowd?
All right, so former President Trump making some statements there to members of the media prior to entering into the courtroom as we see week two rather, of testimony getting underway in his hush money trial. He's been talking a lot about how cold the courtroom is. He said that it's an icebox and he believes they are doing that on purpose.
Was being said out loud on the record in official court proceedings involving the President of the United States. Can you believe this? That is not normal. That is not something that has a lot of precedent in American legal history. And it tells you something enormously important about the pattern of conduct that produced those warnings and about the judicial patience that eventually ran out. Let's start with the January 6th committee subpoena, because that was one of the most dramatic and most high-profile orders for Trump to testify. And the consequences of non-compliance were explicitly described as potentially leading to imprisonment. The House January 6th committee formally subpoenaed Trump. They required him to appear for a deposition and to produce records related to the effort to overturn the results of the 2020 election. And the committee was very clear in its communications about what non-compliance might mean. If Trump refused to comply, the committee could refer the matter to the Department of Justice, and a DOJ referral in that context could lead to criminal proceedings. And criminal proceedings for contempt of Congress in a case of this nature could result in imprisonment. Are you kidding me? The House Select Committee that was investigating January 6th, one of the most serious constitutional events in modern American history, subpoenaed the person they believe was most central to what happened that day. And they made clear that ignoring that subpoena was not a cost-free option. The legal machinery for consequences was clearly and publicly laid out. And Trump's legal team spent weeks fighting the subpoena rather than complying with it. This is wild, and the subpoena fight is really just the beginning of the pattern we are going to trace today. The pattern of being ordered to comply, not complying, fighting the order, and eventually pushing judicial patience to the point where the tools the courts are reaching for are not fines, but something much more serious. And then there is the hush money case, where the jail threat became the most specific and most direct that any judge had directed at Trump in any proceeding. Judge Juan Merchan in the New York hush money case found Trump in contempt for violating a gag order that restricted what he could say publicly about certain individuals connected to the case. He fined Trump for those violations. And then he issued a warning that was so specific and so clear that there was absolutely no way to misunderstand what he was saying. Merchan warned explicitly that continued violations of the gag order could lead to what he called an incarceratory punishment. He required Trump to remove offending posts from his social media platform, and he made absolutely clear that the court was prepared to escalate its response if the non-compliance continued. This is wild. A sitting judge in an active criminal case warning the defendant, who was also the sitting president of the United States, that continued defiance of court orders could result in jail. Not theoretically, not in some distant future if a whole series of additional steps happen first. As a real, specific, approximately available consequence for continued gag order violations. Come on, that is a moment worth understanding in its full historical weight, because nothing quite like it had ever happened in American legal history before. Now let's really dig into the full picture of everything that happened across these different proceedings, because the January 6th subpoena and the hush money gag order contempt are the two biggest pieces of this story, but they are not the only pieces. And to fully understand why the pattern of judicial warnings has been so consistent and so escalating across so many different cases, you need to understand the full arc of how Trump's relationship with court orders has worked across his various legal proceedings. The pattern that emerges when you look at all of it together is not one of isolated moments of tension in individual cases. It is a sustained and consistent pattern of treating court orders as obstacles to be managed and delayed rather than requirements to be complied with. And judges who initially responded with fines and warnings eventually reaching the point where those tools were clearly insufficient, and the language they were using to signal what came next was unmistakably serious. Let's go through all of it carefully and build the complete picture. Start with the January 6th subpoena in more detail, because the legal and political stakes involved in that specific order were genuinely extraordinary, and the way it played out tells you a lot about how the broader pattern of non-compliance has worked. The House January 6th committee spent months conducting one of the most extensive congressional investigations in modern American history. They interviewed hundreds of witnesses. They reviewed thousands of documents. They held public hearings that drew enormous public attention. And at the end of all of that, they concluded that the person most central to what happened on January 6th, the person who could provide the most important and most direct testimony about the planning, the pressure campaigns, and the decisions that led to the events of that day, was Trump himself. So they issued a subpoena, a formal legal order requiring him to appear and to produce documents. And they were very direct about what they believed the subpoena authority meant and what the consequences of defiance would be. Are you kidding me? Because here is what most people do not fully appreciate about a congressional subpoena. This is not a polite request. This is not an invitation that can be declined without consequence. Congress has the legal authority to compel testimony and document production. And the enforcement mechanism for a defied congressional subpoena includes referral to the Department of Justice for criminal prosecution for contempt of Congress, which is a federal crime, which carries potential imprisonment. And the committee made all of that very clear when the subpoena was issued. The legal consequences of saying no were laid out explicitly and publicly. And Trump's team spent weeks fighting the subpoena through legal channels, ultimately preventing the committee from enforcing it before the new Congress took over and the committee dissolved. Come on. But the subpoena fight itself, the explicit invocation of imprisonment as a potential consequence, the formal legal order from a congressional committee to the person they believe was most responsible for January 6th, that is historically significant regardless of how the specific enforcement question ultimately resolved. It established that the legal tools for compelling testimony, including the ultimate consequence of jail, were on the table and being explicitly discussed in the context of Trump's conduct. Now let's get into the hush money gag order situation in much more detail, because this is where the jail warning became the most specific and most immediate and most directly tied to Trump's actual behavior in an active legal proceeding. Judge Merchan issued the gag order in the hush money case to protect specific individuals connected to the proceedings, witnesses, court staff, jurors, from being publicly attacked or harassed by Trump or his supporters. The gag order had clear parameters. Trump was not supposed to make public statements about these specific individuals in the context of the case. And Trump violated it multiple times. He made posts on his social media platform that the judge determined crossed the line the order had drawn. And Merchan's response was to find him in contempt and impose fines across multiple violations, which, and I want to be really honest about this, is not a lot of money to someone with Trump's resources. That is not a number that creates serious financial pressure on a person at that wealth level. Can you believe this? Fines for multiple contempt violations in a criminal proceeding. So Merchan made very clear in his contempt ruling that the fine was not the end of the available consequences. He warned explicitly that continued violations could lead to an incarceratory punishment. He required specific remedial actions, removing the offending posts. He put Trump on notice in the most direct and official language a judge can use that the court's tolerance for continued defiance was reaching its limit. And the reason that warning landed as heavily as it did, the reason it was so widely covered and so significant, is that it was not a hypothetical statement about what might happen in some imagined future scenario. It was a judge who had already found contempt, had already imposed fines, and was now explicitly saying that the next step on the escalation ladder was incarceration. That is a very different kind of warning than a general statement about what courts can do. That is a specific judicial communication about what this court was prepared to do with this defendant if this specific conduct continued. And the contempt and gag order situation connects to a broader pattern that runs through virtually every major Trump legal proceeding. The pattern of treating court orders as negotiable, of pushing the boundaries of what judges will tolerate, and of discovering that different judges have different tolerance levels, but that all of them eventually reach a limit. In the New York fraud trial, Judge Engoron was also dealing with behavior that repeatedly pushed against the rules of his courtroom. He fined Trump for a gag order violation in that proceeding, too. He warned that Trump's right to be physically present in his own trial could be forfeited if he continued to disrupt the proceedings. He told Trump's lawyers to control their client because the courtroom was not a political rally. The specific tools Engoron used were different from Merchan's tools because the two cases were procedurally different, but the underlying dynamic was the same. A defendant who consistently treated court orders and courtroom rules as obstacles to be pushed against rather than requirements to be followed, and judges who responded with escalating consequences and increasingly direct warnings about where the escalation was heading. This is wild. The extraordinary thing about the pattern when you see it across multiple independent proceedings before multiple different judges is that it cannot be explained away as one judge with a personal grievance or one court with a specific political motivation. These are independent judicial officers in independent proceedings applying independent legal standards. And they all kept reaching the same conclusion about the same defendant, that compliance was not happening, and that the tools available to courts to compel compliance were being systematically tested by someone who appeared to believe that the normal enforcement mechanisms of the legal system did not fully apply to him. And that belief, if we are being honest about what the pattern of behavior suggests, is actually one of the most important things the entire story reveals about Trump's approach to the legal system. Because the approach is not just about any specific case or any specific order. The approach appears to be a systematic strategy of treating every court requirement as the opening position in a negotiation rather than as a binding obligation. File the motion to delay, fight the subpoena, post the violation, and see what the judge does. Accept the fine if the fine is manageable. Keep pushing until the escalation reaches a point where the political or legal cost of continued defiance exceeds the benefit. And the strategy works or has worked up to a point because the legal system genuinely does move in stages, and there genuinely are steps between an order and a jail cell that take time and legal effort to traverse. Come on. But judges are aware of that strategy when they see it. And the escalating directness of the jail warnings across multiple proceedings suggests that judges who have seen this pattern are trying to communicate clearly and specifically that the stages between an order and incarceration are not infinite, and that the end of the road is visible from where things currently stand. Let's bring this home now, because the legal process details across all of these cases are important. But what every person watching this really needs to walk away understanding is the bigger picture of what all of this means and where it is pointing. The January 6th committee subpoena was one of the most significant legal orders ever directed at a sitting or recently departed president. And the fact that it was defied without immediate consequences does not mean it was consequence-free. The committee issued that subpoena based on extensive investigation and a determination that Trump was the most important and most central witness to the events of January 6th. They had reviewed testimony from hundreds of other witnesses. They had reviewed thousands of documents. And they concluded that the full picture of what happened could not be complete without Trump's testimony. The potential consequences of defiance, criminal contempt, referral to DOJ, potential prosecution, potential imprisonment were explicitly laid out in public. And Trump's team responded by fighting the subpoena rather than complying with it. This is wild. The committee dissolved before enforcement could be completed through the normal legal channels. But the subpoena fight itself established something important for every subsequent proceeding. It established that Trump's approach to legal obligations involving his own testimony was to fight rather than comply, to delay rather than produce, to treat the court order or committee order as the beginning of a legal fight rather than the end of the question. And that approach has shown up consistently across every major proceeding that has followed. Are you kidding me? Judge Merchan's jail warning in the hush money case is the single most direct and most documented example of a judge explicitly putting incarceration on the table as a specific consequence for specific conduct by this specific defendant. Fines for gag order violations, a requirement to remove offending posts, and an explicit warning that continued violations could result in incarceratory punishment. That sequence of events documents precisely how judicial patience works when it runs out. First the order, then the violation, then the fine, then the warning that the fine is not the ceiling of available consequences. And Merchan's warning was not issued in a moment of judicial frustration or as a rhetorical flourish designed to make headlines. It was a careful, documented, on-the-record judicial communication about the specific legal consequences that specific conduct could trigger in that specific proceeding. Come on. And the significance of that warning goes beyond the hush money case itself because it established publicly and specifically that at least one judge with direct authority over a Trump proceeding had reached the point where the word jail was being used not as a theoretical possibility, but as an approximately available consequence for continued non-compliance. That is a threshold that matters for how subsequent proceedings are understood and how future warnings are interpreted. The broader pattern of treating court orders as negotiable rather than binding is the most important and most revealing thing about Trump's legal conduct across all of these cases put together. Because no single contempt finding or gag order violation or subpoena fight tells the full story. It is the accumulation of them across the January 6th subpoena, across the hush money gag order, across the fraud trial, disruptions and warnings that reveals a consistent approach to judicial authority that judges themselves have documented in the official records of these proceedings. Can you believe this? And when you look at the judicial responses to that approach, the escalating fines, the direct jail warnings, the instructions to lawyers to control their clients, the threats to revoke the right to be present in one's own trial, you see the other side of the same pattern. Judges who see non-compliance apply the available remedies, find those remedies insufficient, and escalate to tools that carry more weight. The jail warnings are not the starting point of that escalation. They are the product of it. They represent multiple rounds of lesser remedies failing to produce compliance and judges reaching for the most serious tool in the compliance enforcement toolkit. This is wild. And the fact that multiple independent judges in multiple independent proceedings have reached that same point with the same defendant tells you something very important about the underlying pattern of conduct that produced those warnings. What all of this means for the rule of law and for the accountability question that sits underneath every individual case is the deepest and most important point of everything we have covered today. The legal system's ability to function depends on people, including and especially powerful people, complying with court orders. Not because they feel like it, not because the political cost of non-compliance is too high in a specific moment, but because the rule of law means the orders of legitimate courts are binding on everyone, regardless of their power, their fame, or their political position. When someone systematically treats court orders as negotiable, they are not just causing problems in their individual cases. They are testing whether the legal system's enforcement mechanisms are strong enough to compel compliance from someone powerful enough and resourceful enough to fight every order through every available legal channel. Come on. And the answer that has emerged from Trump's various legal proceedings is complicated. The system has tools, contempt findings, fines, gag orders, jail warnings, and has deployed them. But the tools have limitations when the defendant is willing to absorb fines and fight every order through extensive legal maneuvering. The places where those limitations have become most visible, where judges have had to reach all the way to the jail warning, are the places that tell you most honestly about the gaps between what the legal system says should happen and what actually happens when the defendant has enough resources and enough political support to push back indefinitely. So where does all of this go from here? The hush money convictions are still working through the appeals process. The gag order warnings are part of the permanent record of those proceedings. The January 6th subpoena fight established patterns that are still relevant to how compliance questions get handled in subsequent investigations. Any new legal proceeding involving Trump now exists against the backdrop of a documented history of judicial warnings, contempt findings, and escalating consequences that make clear the court's tolerance for non-compliance has real limits, even when exercising those limits is complicated and slow and procedurally difficult. The judges have been patient, the tools have been escalating. And the question that remains open is whether the ultimate consequence that has been warned about, the one that judges have explicitly named as the next step if the defiance continues, will ever actually be imposed. The warnings have been issued, the record has been made, the legal system has documented the pattern, and now the country waits to see what happens when a president who has consistently pushed the boundaries of judicial authority finally encounters a judge who means exactly what he says about where the escalation ends.